Good evening, good afternoon, and good morning. And thank you very much to those who are joining us live or who will perhaps be watching this recording later. This is the 11th session of the Africa in the Moot Open Access Education and Training Series in the context of the 31st Willem C International Commercial Arbitration Moot. My name is Erin Cornea. I am a senior associate at De Brouw Blackstone Westbrook, practicing international arbitration in the Netherlands, and I am also very proudly a director of Africa in the Moot. So for those of you who are joining us and are new to the program, Africa in the Moot is a non-profit volunteer-based organization which supports sub-Saharan African teams to participate in the Vis Moot. And this is the largest commercial moot in the world, and typically draws hundreds of university teams from around the world to compete. But historically, sub-Saharan Africa's participation has been less than 1% of that. And we at Africa in the Moot are on a mission to change this. Knowing that there is awesome talent on the continent, we support teams with coaching, training, funding, and access to resources, together with our very valued partners, so that they can best participate in this wonderful educational journey that is the 8 months of the Vis Moot. And we also aim, through our mission, to promote diversity and equal representation of Africans in the moot, which of course has a long-term positive consequence of also promoting diversity, equal representation, and inclusion in international arbitration or international legal practice. So talented future lawyers have a lot to contribute to the legal landscapes, both internationally and in their domestic spheres, and to really add a conversation and a valuable voice to that arbitration and legal practice discourse. And in order to facilitate them to try and achieve that and to contribute to their career development, we at Africa in the Moot really prioritize education, network, and exposure, and our global community, very importantly. And one of the ways that we do that is through this very education and training series and other exciting initiatives such as the award-winning East Africa Pre-Moot. So to hear a little bit more about that, please stay tuned at the end of the session. But now, speaking of the moot, I think that's, of course, why all of you have joined and are watching this recording, if you are. It's a very, very exciting time today, being just 3 days away from the due date of the respondents' memoranda, which will also be the close of the written phase of this year's moot. And then, of course, another exciting phase begins, and that is the oral rounds, which will see teams from around the world continuing to develop their arguments as they participate in pre-moots and practices on their respective roads to Vienna or Hong Kong, or both if you're lucky. And of course, you all know by now very well that the rules applicable to the moot problem this year are the ICC rules. So for that, we are extremely fortunate to be joined by two counsel from the International Court of Arbitration who are based in Paris. Starting with Benjamin Ngeno, he is a deputy counsel in the common law team, which manages approximately 120 cases arising from several jurisdictions, primarily in Africa and in Europe, which have a nexus. Prior to joining the ICC, he trained and worked with leading dispute resolution firms in Nairobi, Geneva, and Brussels, specializing in litigation and international arbitration. He holds an LLM in international dispute settlement from Geneva's Graduate Institute and the University of Geneva, and a Bachelor of Laws from the University of Nairobi. He is also qualified in Kenya. And second, and definitely not least, is Colleen Bacquet. She is a counsel of the common law team at the ICC, also based in Paris. And as counsel, she likewise oversees the international commercial arbitration cases under the ICC rules, which are related to the UK, Ireland, and common law countries in Africa. Colleen has completed her legal education in the United States and France, and has experience working with law firms in Italy and the United States too. So I will stop talking on my end from now and hand over to those who I'm sure you're much more interested to hear from today. Just before I do, please do post questions in the chat as we go along, and these questions will be addressed at the end of the session. And with that, I hand over now to Colleen and Benjamin. Thank you so much for being here with us today.
Thank you very much, Erin. It's a great pleasure and a delight to be able to share and, exchange views and experiences about arbitration, and particularly to talk about the ICC rules of arbitration, in a sense, touching on the Vis Moot, especially in a year when the ICC's moot rules are being applied to the moot. it is also a great pleasure to be a participant and a contributor to Africa in the Moot, which is a very great initiative. We thank you, Erin, and everyone else who is involved in this wonderful initiative. And we will go straight into it, noting that we are a bit lost for time. And we will start by we'll just start by giving you a background of the ICC to put the institution in context of the international arbitration practice. So first thing we'll do is tell you about the history. ICC was established in 1919, and the idea behind the ICC was to facilitate a trade, which was seen as a way of minimizing parties disagreeing or going to war owing to business disagreements. So business entities talking, and if they were talking and engaging with each other more, then there was more trade. And where there's trade, there's prosperity, and where there's prosperity, there's less war. And so the ICC began in 1919, and currently it does represent at least 45 million companies across 130 countries. And it does play different roles. The ICC has one wing, which is what we will be discussing today, which is the dispute resolution services, but it also does other things, which is advocacy for business. So we call ourselves the global or the leading voice of business across the world. So we have the dispute resolution service, which administers the ICC Arbitration Rules. It also runs the ICC International Center for ADR. And as we will go ahead in the next slides, we'll see that having administered various sets of rules, the ICC also does have an interesting structure. What sometimes gets easily mistaken, we have what we call the ICC International Court, which is not a court of justice like many of us would imagine, but it is a body of the highest level of dispute resolution professionals across different jurisdictions who sit together and participate in discussions, particularly with respect to decisions that need to be taken under the rules. The court is led by a president who you may know, Claudia Solomon, and under her, there are 17 vice presidents who then also deputize for her when she's not chairing sessions. And on top of that, then there are court members. The court also has case management teams in the Secretariat. The Secretariat does the role of supporting the ICC. And there are 12 case management teams, 7 of which are based in Paris. And the rest are based in Hong Kong, Singapore, New York, Sao Paulo. So we also have the ICC Commission, which does the legislative drafting, which is how the rules are, first of all, developed and constantly improved. And as we saw previously, there's the ICC ADR Center, which administers the ADR rules. And on to the next slide, please. So we already, in a sense, have covered this, but the ICC does have policy and advocacy body, and the court is independent and was established in 1923. Last year we did celebrate the centenary, and it has offices right across the world. And the hallmark or the crown jewel of the ICC is that it scrutinizes arbitral awards rendered by tribunals to ensure that they are in accordance with the rules. I think Colleen may touch on scrutiny a little bit later, as counsel she'll give you a flavor of it, but we'll move on faster just to distinguish between what the ICC court does and what arbitral tribunals do. So the ICC is an administrative body primarily. So the tribunal is the one that decides the dispute. The ICC does not. And this is provided under Article 1.2 of the rules, which says that the ICC court itself does not settle disputes. It only administers arbitrations. So the distinction then would be, we have the ICC Court of Arbitration in Paris, which administers disputes, does not resolve them. supervises the work of tribunals, helps in constituting of arbitral tribunals, and controls time limits under the rules and scrutinizes awards, whereas arbitral tribunals determine or decide cases on the merits, establish terms of reference, decide on allocation of costs, and all other matters that need a substantive determination vis-a-vis the parties. If we may go to the next slide, please. So the ICC Secretariat is very diverse, and this is one of the joys of working with this institution, bringing together at least 80 staff members from literally every corner of the globe, with several nationalities and languages, and each team of the 12 case teams is headed by one counsel. The common law team, which is before you today, is headed by Colleen, who will speak a bit later, and several deputy counsel per team. At least for the common law team, we are 2 deputy counsel. The day-to-day, what we do is we correspond with arbitrators. We give them guidance on how the rules, how to apply some aspects of the rules, or when they have questions about financial aspects of the rules, we also guide them on that. And then also, we are in contact with the parties from the moment when they file the request for arbitration to the moment we notify the request of arbitration to parties, and every other correspondence and exchange that takes place between the parties and the arbitrators. The ICC is in the background, just monitoring the procedure to ensure that everything is done in compliance with the rules. So you can imagine that we are doing this for about 70 cases per deputy counsel, 120 cases in total. So it's a really good feel and experience we get of the arbitration practice. So that is a secretariat. But what does the court do? The court determines the place of arbitration where the arbitration agreement does not provide for the place. It also examines the ICC arbitration agreement to see whether it is a valid and binding prima facie ICC arbitration clause. It also then confirms and appoints arbitrators either who have been nominated by parties, that's confirmation, or appoints where parties have been unable to agree on an arbitrator or have requested that the court does the appointment of the arbitrator. And like I told you, we monitor the arbitral proceedings from beginning to end, and then once the award is rendered by the arbitrator, the draft is sent to the ICC for scrutiny, and this involves reading through the award and looking out for errors of computation, errors of grammar, and also just ensuring that as much as possible the input of the court members from various jurisdictions, that the award is prepared in such a form that it will be enforceable in the jurisdiction where it will be enforced. So this is the importance of the scrutiny process, that the goal of the ICC's Court of Arbitration is to render and to ensure that we have enforceable awards that are rendered by tribunals. And then lastly, we also monitor the financial aspects of the case and ensure that there is enough funds on file to remunerate the arbitrators and also take care of the administrative costs of the case. So as we had mentioned earlier, there are several decisions that the court takes. And when we say decisions, it just helps to give us background in a minute that when we receive requests for arbitration from parties, what we'll do is we'll read through them and we'll prepare what we call an agenda. An agenda is a brief memo to the members of the court, telling them that there are some issues that really need your input. And for example, parties have not been able to agree on the number of arbitrators, or parties have not agreed on the place of arbitration. We would need you as a court to fix the place of arbitration or to determine the number of arbitrators. And you can be guided by these provisions of the rules and this practice, the past practice of the court. And then the court does take these agendas, which is a memo, same way you prepare a legal brief, and they use this and they read through it and deliberate amongst themselves and then make a decision. So kind of decisions the court makes are, one, is there a prima facie jurisdiction of the parties of the claims based on the arbitration agreement? Can cases be consolidated under Article 10? If there's no place of arbitration, can the court fix a place of arbitration? And it does. Determining the number of arbitrators, fixing advances on costs, which is the financial aspect I mentioned earlier, approving terms of reference. This is where parties aren't able to agree on the terms of reference, or one party is not participating and therefore not signing. The court does need to approve the terms of reference. And finally, the crown jewel is scrutiny of the arbitral award.
This illustration demonstrates how there is sort of an interplay between the parties. If they have not provided for things such as the place of arbitration in the arbitration agreement, or they haven't provided for the number of arbitrators, then the court will step in the absence to sort of fill in those holes in a similar way as also interacting with the tribunal, for example, with the scrutiny of awards. So the court plays an interesting role in working with both decisions that need to be made in the absence of a decision by the parties, or where there's issues with the tribunal. For example, if an arbitrator has been challenged, having an objective body that's able to step in and make those decisions.
I think it also helps to mention that the court does not interfere with the decision-making power of tribunals. The court makes suggestions, but ultimately and always the power to make decisions or determinations rests with the arbitral tribunal. So the ICC rules also provide for additional features. These are emergency arbitrator provisions where parties need to obtain interim measures before the constitution of an arbitral tribunal, and also expedited procedure provisions where the case process is shortened and made more flexible in light of the amount in dispute. In this case, normally cases below $3 million are subjected to the expedited provisions. So again, the advantages that do come from the ICC as an institution is that we do supervise the constitution of the arbitral tribunal. We also, through the rules, are able to administer complex arbitrations, such as the one you will be seeing or are already seeing in your Moot problem, with multi-contract, multi-party arbitrations with joinders and consolidations. We're able to put together emergency arbitration proceedings and appoint an emergency arbitrator within the shortest time possible. We're able to administer expedited procedure provisions to ensure that the cases are determined as fast as possible, especially where there's a smaller amount in dispute. And we are also able to offer the unique service of scrutiny of arbitral awards, which is, again, the crown jewel. Yeah. Right. So this will move through pretty fast in the sense that the ICC does provide a standard arbitration clauses, which guide parties as to ensuring that you do have a valid arbitration clause. We do provide, we have seen very interesting arbitration clauses that do come to us, and some of them sadly end up being pathological. But where there is a model arbitration clause like this, it does help parties have a clause that's enforceable and ensures that the intention of the parties to refer the dispute to arbitration or ICC arbitration is achieved. And this is the case here. We will provide suggestions of what to include in the arbitration clause, the institution, the place of arbitration, the number of arbitrators, the language of arbitration, and the applicable law for the basic arbitration clause. And there's the more complex ones in the next slide, which will suggest a method of constitution of the arbitral tribunal, which will have multi-tiered dispute resolution procedure, which will provide for confidentiality, set out provisions on enforceability, multi-party considerations, modified time limits, and also remedies and cost allocations. Some clauses we've seen do provide for consolidation of cases, so these advanced options do feature as well. So what's the life cycle of ICC arbitration like? As a secretariat, on my desk as a DC, DC is a short form for deputy counsel. The first thing we do is we receive the request for arbitration from a party. Once we peruse it and looked at the clauses, that if there was a valid arbitration clause, then we will notify this request to the respondent. And respondent then will have 30 days within which to file its answer and counterclaims. And then after that, a reply is filed. The next stage after that is the tribunal is constituted. Within this time, parties will either have given comments on the number of arbitrators they want, or maybe even suggested the arbitrators they would like to have appointed. If not, then the court steps in and does that for them. So the arbitral tribunal then is constituted. And upon that, we do what we call the transmission of the file to the arbitral tribunal, which is all the documents we've received from the request up to the date of the constitution, that then is sent off to the tribunal. The tribunal then needs to establish the terms of reference if it's a regular case. However, if it's a case that is being conducted under expedited procedure provisions, then this terms of reference is not a necessity. The tribunal can move straight to the case management conference. And it does then set out a procedural timetable for the parties, of course, in consultation with the parties, that sets out what will happen from the statement of claim right up to the date of the final hearing and the post-hearing briefs. In between all this, or right after the procedural timetable, is the conduct of the arbitration phase. A lot goes on here, where parties engage in discovery procedures, parties exchange various rounds of submissions, statement of claim, statement of defense and counterclaims, rejoinders, and all these is going on during the conduct of the arbitration, all this building up to the hearing. And then a date is reserved by the parties where the hearing takes place. It can either be in person, anywhere in the world, or it can be virtual. And we've seen post-COVID, a lot of hearings are taking place virtually. And the hearing takes place and the parties present their evidence before the tribunal. And then at the end of the hearing, the tribunal closes the proceedings and then proceeds and retreats to write their word. And after a few given duration of time, they do send that draft award to the Secretariat and the court for scrutiny. And this is then sent over to the court, who review their word and make comments, suggestions to the arbitrators and send it back to them. They are at liberty to take this into consideration and improve the quality of their word. And then they sign their word and send the final copy of their word, either electronically, if the parties have agreed to that. So electronically means in a PDF format, or physically. Sometimes you do get volumes of thousands of pages coming to us of arbitrator decisions. And then the Secretariat's work is to notify that award to the parties, which then brings us through the full life cycle of ICC arbitration proceedings.
Yes, and just going back to what Benjamin was discussing earlier, sort of the breakdown between the powers of the court versus the arbitral tribunal, you can see that the court and the Secretariat tend to have the majority of their interactions sort of at the beginning and the end, basically before the tribunal is constituted, and then at the award stage to do that final scrutiny and notification process. So you can see we're really there to make sure the proceedings get off the ground. Again, we're there to make sure that the proceedings abide by the ICC rules and are being properly applied. So it's very much at the beginning before we have the tribunal. At that point, the tribunal's role is to decide the merits of the case, and we take more of a step back in terms of monitoring the proceedings for timeliness and also the financial aspect. And then if there are any issues with the tribunal, but that's really sort of helps demonstrate the interaction between when we have our primary role and when that is engaging with the tribunal.
Right. So just as to a few elements regarding the request for arbitration. Of course, once you do file your request for arbitration, you do have to send it with the filing fee, which is normally about $5,000 US. And then the request does need to have particular elements set out to guide the Secretariat as to how we will notify it. An important consideration is the respondent's address. you'd be surprised. Sometimes we do get requests that do not have the respondent's address, and we have to go back and request for it. Either could be an email address or physical address. And also, it does need to set out the basis of the request. And this should be the arbitration agreement where it's cited. That we always ask for the agreement. We then look at the agreement and see whether there is a valid ICC arbitration clause. It helps, and it's also necessary for us if you as future practitioners, this is a good note to quantify your amount in dispute. This helps in us then setting the necessary administrative fees for the case, and also your details as claimants' representatives, your observations concerning the number of arbitrators, the place of arbitration, and any other additional documents. All these are necessary because they then reduce the number of administrative hurdles that need to be jumped to get the arbitration started. If you do not put the number of arbitrators in your arbitration agreement or do not make comments in your request, then it means it takes longer for your arbitration to take off, because then it has to go to the court, for the court to make a decision, then come back and we notify the party of the decision. And so sometimes efficiency is party driven, and party driven means the parties take lead and give all this necessary information so that the arbitration can take off smoothly. Then we then transmit this to the respondent, as we had mentioned earlier, and they do provide their response within 30 days. And the Secretariat also invites, if there are counterclaims, we do give claimant 30 days also to respond to the counterclaims. So we also have situations where once we've notified the request, there is no answer that's filed. And that does not bar the arbitration from going forward, because it is deemed that parties in incorporating an arbitration clause into their contract subjected themselves to this process. And therefore, we will notify respondent that we have not received an answer within the time limit, and we are then taking steps to ensure that the arbitration proceeds. And we'll go ahead and constitute the arbitral tribunal. We invite the court normally to appoint an arbitrator and then transmit the file to the arbitral tribunal. So, like Colleen mentioned, our work as the court and the Secretariat is very heavy at the beginning and the end of the proceedings. The heavy part is always building up to the constitution of the arbitral tribunal. We have various formulations where, first of all, claimant does nominate the arbitrator. It's preferred if it's a 3-member tribunal. In the request, claimant will nominate a co-arbitrator. Respondent, in its answer, or in a request for an extension of time to submit an answer, will also nominate its preferred co-arbitrator. Then what happens is the Secretary General confirms these arbitrators. So once we have 2 arbitrators in place, then we fall back to the arbitration clause. If it does provide a mechanism for appointment of the president, then we invite the co-arbitrators or the parties to proceed with the mechanism for appointing of the 3rd arbitrator, what we call the president. But if the arbitration clause does not provide a mechanism for that, then the court will appoint. And normally, the mechanisms that are provided are, there could be a joint nomination by the parties, or the co-arbitrators jointly nominate one individual who will become the president of the arbitral tribunal. Once this nominations are done, then again, the Secretary General steps in to confirm this arbitrator who has been appointed either by the parties or by the co-arbitrators. In terms of reference, like we had mentioned, once the file has been transmitted to the arbitral tribunal, they are required then to set up or to draft the terms of reference. And these basically is a contract between the parties and the arbitral tribunals as to how the arbitration will be conducted. and it sets things in a nice framework and a guideline for the conduct of the proceedings going forward. So it does set out the parameters, sets out the issues in dispute, sets out who the parties in dispute are as well. And this then provides clarity. It also helps clean up some issues. For example, sometimes parties do not agree on the language of arbitration in the arbitration clause. They didn't set it out. And this first conference or these terms of reference then provide a chance for the parties to clearly set out some of these missing procedural aspects or procedural issues that then make the arbitration more efficient to conduct. And importantly, it does frame the issues for determination, because once the issues are set out in the terms of reference and they're signed by the parties, then a party cannot introduce new claims unless these are agreed upon later. So it does, in a sense, set a framework for what will be determined by the arbitral tribunal.
All right, so moving on to some of the more interesting types of procedural issues that we see and that are relevant to the moot problem this year, we are going to discuss some multi-contracts and consolidations issues. So first of all, under the rules, we are now able to have claims be heard that are brought under multiple contracts. This has not always been the case, but it does allow for claims that arise in connection with more than one contract to be made in a single arbitration, which allows for proceedings to be more efficient in that they are able to decide claims all in one bundle. Parties do not have to engage counsel to work on multiple cases. From our end, it's also procedurally efficient. If we're sending out similar communications in multiple cases, we're able to just treat the issues as one single arbitration. And it also avoids any issue of potentially conflicting decisions by arbitral tribunals deciding on claims that might actually be interrelated but are conducted in different cases. So this is an important innovation to be able to decide claims, even though they may have different contracts and they might even have different arbitration agreements, that can still be decided in the same dispute. So in these multi-contract scenario, as we saw under Article 9, it's subject to provisions including Article 6.4. And this is something that we are often bringing decisions to the court. For example, when we have questions about jurisdictional objections that are raised by respondents or in the absence of an answer. So that is when we bring to the court this question of whether or not they're prima facie satisfied that an arbitration agreement under the rules may exist and bind all parties, and that the arbitration agreements are compatible. And I bring this to you, although it's not the same article that is used for consolidation, but because particularly the issue of compatibility is quite relevant to the question of consolidation, when we have cases in which there are either multiple agreements with the same parties, or when there are multiple parties in the same agreements, we need to consider some of these similar sort of questions. The compatibility obviously only arises when there are multiple arbitration agreements, but it still is a similar analysis that we find being presented to court. So to give you an example of a multi-contract scenario, this was a case in which there was an objection to jurisdiction. All of the parties were participating. However, not all of the parties were signatories to the contracts. So not only were there multiple agreements, there were different signatories to each of the agreements. So there were several different buckets of contracts. There were first engineering, procurement, and construction agreements, the EPC agreements, as well as operation and management contracts. We often see these multi-contract situations arise in relation to large projects dealing with energy or infrastructure or construction, also in the context of joint ventures, where there are often framework agreements that set out the overall goals of the projects. And then we see subsequent agreements that deal with subcontractors, or that, as in this case, require guarantees. So in this situation, the claimants and respondents were both signatories to the EPC agreements and the O&M contracts. However, there were also separate agreements that the additional parties, who were parent companies of the claimant, had entered into as guarantors. And this is also something that we see quite frequently, where there are agreements that not all parties are signatories to, but that make up a single economic transaction, or that we understand to be interrelated, even if not all parties are signatories to all of the agreement. So in this case, respondents and claimants were initially engaged in the proceedings, and respondents wanted to join the additional parties as guarantors. That way, they were able to decide issues that if claimants were found liable, then the guarantors were also already included in the arbitration and would avoid further proceedings to be able to actually get an enforceable decision against those guarantors. However, the additional parties objected to the jurisdiction, claiming that as they were not signatories to either of the relevant agreements, that they should not be a proper party to the dispute. So under the 6-4 analysis, the court was invited to first consider whether arbitration agreements that bind all parties may exist. So that means, have all of the parties demonstrated a willingness to subject themselves to ICC arbitration in their respective agreements? And are those agreements compatible? Finally, is there some indication that the claims can be determined together in a single arbitration? So let me just set out, this is what a table that was used in the agenda that we prepared for court, so you get an idea of how we put these issues to the court for their consideration. You can see we have the EPC agreements, the O&M agreements, as well as the separate parent company guarantees. And as you can see, not all parties are signatories to all of the agreements, but more than that, the terms of the agreements themselves had some differences. So the question of whether or not all parties may be bound by ICC arbitration, that was a clear-cut yes. They all referred to the ICC in the arbitration agreement. However, the EPC and O&M agreements only provided for 3 arbitrators, in contrast to the parent company guarantees, which provided for 1. So as you can see, the parties did provide for how many arbitrators they wanted, but in this case, they had different numbers. The places of arbitration were also distinct between the agreements, with some providing for Mexico City and others providing for Madrid. They also had some varying applicable laws, notably the laws of Mexico versus the laws of Spain. And finally, the language was also found to be different in some of those agreements. So when deciding whether or not these arbitration agreements are compatible, the court did find that the additional parties, although not signatories to the arbitration agreements in the underlying contracts, that they participated in the performance of the agreements by acting as guarantors of the claimants in those proceedings, and that demonstrated that they could be bound, or that the court was satisfied that there was at least a prima facie indication that the additional parties had participated and therefore were properly joined to the proceedings. In terms of the compatibility, the EPC and O&M agreements were found to be compatible because they provided for the same number of arbitrators, the same applicable law, and for the same language. This is in contrast to the parent company guarantees, where they had a different number of arbitrators and a different place of arbitration, as well as a different language and different laws. So in particular, the court will consider arbitration agreements incompatible when they provide for a different number of arbitrators, because this sets out the nature of the proceedings in a way that can't be cured. This is distinct from if the agreements had provided for 1 or more arbitrators in the parent company guarantees. In that situation, we consider that these incompatibilities can be cured, because we can say, even if the claims are decided by a 3-member tribunal, that's still consistent with the arbitration agreement that provides for 1 or more arbitrators. The place of arbitration is also something that is necessary to find that the arbitration agreements are compatible. This is another one that can be cured if, for example, one arbitration agreement provides for a place and the other arbitration agreement is silent. In that situation, there's no conflict if the parties subsequently agree to have the same place of arbitration where it was otherwise silent, or the court may fix that place in appropriate circumstances. And when considering whether or not it could be decided in a single arbitration, we also look at the identity of the parties, the single economic transaction, as I mentioned, the fact that it was a guarantee for a specific project demonstrated that it was part of a single economic transaction, and that these the EPC and O&M agreements were compatible. However, the parent company guarantees could not be the basis for the arbitration or for claims to be brought under those because of the fact that those agreements were found not to be compatible. So turning to consolidation, a hot topic for the Vis Moot preparations, this is when there are two separate proceedings pending before the ICC and the parties request that they be merged into a single proceeding. So in such a circumstance, when a party makes a request, the court may decide to consolidate the arbitrations, either where the parties agree, in which case it's quite straightforward. If the parties agree to have their cases consolidate, the subsequent case will be consolidated into the first. If it's a situation where there isn't party agreement, for example, if one of the parties objects to a request for consolidation, then the court will be invited to consider whether or not all of the claims in the arbitration are made under a single arbitration agreement or agreements, or in circumstances where there are multiple arbitration agreements, as discussed in the previous example, they will have to consider whether or not the arbitration clauses are between the same parties. So it will require identity of the parties, whether the dispute arises from the same legal relationship, and whether or not the arbitration agreements are compatible. So again, the analysis of compatibility that we find with respect to joining parties or prima facie jurisdiction is very similar to the analysis under compatibility for consolidation purposes. So first, to give you an example of a 10B consolidation, this is a situation where there's a shareholders agreement. There are multiple parties that are signatories to the agreement, but it is one single arbitration agreement with different parties. In this situation, we can see how some parties play different roles in separate proceedings. For example, in this case, case 1 was brought by party B as claimant against party C as respondent. Following the request by party B, party A as claimant brought claims against party B as respondent. So in this case, party B was acting both as a respondent party in case 2 and as a claimant party in case 1. Both of these cases were brought under the same arbitration agreement, and so it makes sense in this situation for procedural efficiency, for those considerations I mentioned earlier, to have one single arbitration. And the parties here can act as both claimant and respondent. For example, one party may be considered to be bringing claims against another while it also is defending against claims that have been brought against it. So in this situation, it's a 10B claim. We consider that where the arbitration agreements are the same, then there isn't the issue of compatibility, as I mentioned, and that the arbitration may proceed in a single consolidated case in such circumstances. So the 10C question is a bit more difficult. This is when there are several arbitration agreements, but the same parties. And so that's really the key about in terms of the requirements of a 10C consolidation. They must be the same parties in the cases that are requested to be consolidated. So again, just to highlight some of the questions about compatibility, where the place of arbitration is different, we are not going to be able to consolidate for a lack of compatibility of agreements. Where the language is different, this might be a question of the parties subsequently being able to agree. As Benjamin mentioned, this is sometimes where terms of reference can clean up some of the procedural issues. This doesn't necessarily pose as big of a problems from the court's perspective as the number of arbitrators or the place of arbitration. And the parties may subsequently agree in the terms of reference to have a different language for the proceedings or to decide on the allocation of who would be responsible for any translations that might be required in order to have all of the documents in one language. Other issues of compatibility might arise with respect to the mechanism for choosing the tribunal. And so if one provides for the parties to jointly nominate the sole arbitrator versus the court appointing the sole arbitrator, that might be something that the court will consider whether or not that can be cured. Again, the number of arbitrators also is something that we will find to be incompatible where they're different and where there isn't a mechanism for curing those incompatibilities. Applicable law is another one that isn't something that we necessarily find would prevent consolidation, but it will be a factor that's considered in the question of whether or not the agreements are compatible. Some other things that are also taken into consideration are the timing of the request for consolidation. For example, it's unlikely that the court is going to find it appropriate to consolidate a case if a subsequent case is brought right before the hearing is about to occur in the proceedings. In that situation, the parties are not necessarily able to effectively respond to all of the claims that were brought in the previous arbitration, or to be able to express their agreement to the arbitrators. So the timing of the request for consolidation is something that will also be kept in mind when the court is confronted with a question of consolidation. So to give you an example of this 10C situation, we had a case where a claimant filed 2 requests against the same respondent under separate arbitration agreements. In this case, there was not an issue of compatibility because the arbitration agreements in the separate documents were actually in identical terms. So that aids the question of compatibility, and the court doesn't necessarily need to consider that issue when the terms of the arbitration agreements themselves are in fact identical. So instead, the question that the court will ask is, are the disputes in relation to the same legal relationship? Again, there will also be the issue of compatibility, but in this situation, it really was a question of whether or not the arbitrations arose in the same legal relationship. Would it make sense for a tribunal to be deciding on these issues in the same arbitration proceedings? Because if they don't necessarily rely on the same economic or legal relationship, then it may actually be more burdensome to have different types of evidence, different types of experts, different real legal questions that are facing the tribunal, and it doesn't aid that goal of procedural efficiency by allowing consolidation. So in this case, it was found that both contracts related to an ongoing infrastructure project for civil works in terms of upgrading roads, and that the court found to be a single legal relationship, that both agreements arose out of one interaction or one overarching project, and that therefore it did serve those questions of procedural efficiency to allow for the cases to be consolidated. As I mentioned, some other elements that might be considered were the stage of the proceedings. So in the cases, the parties had nominated the same co-arbitrators, which also demonstrates an intention by the parties that these questions could be decided by the same tribunal. We've seen situations where one party has requested consolidation of a case because it's between the same parties. It might even be related to the same legal relationship. However, they made the argument that they wanted to have a tax expert as an arbitrator in one case versus the actual underlying merits of the dispute in another, which related to a different type of agreement. And therefore, they thought that they wanted to have a tribunal that had expertise in the subject matter. So even in cases where there might be a same legal relationship, parties might have reasons for arguing that it's not appropriate to consolidate. In this situation, the co-arbitrators were the same, and that demonstrated an intention and an ease of consolidating. Additionally, the parties were represented by the same counsel, and again, we're at a very early stage. So these are some of the issues that the court will keep in mind when confronted with an application for consolidation. So we also have some opportunities to get involved, but I think that we can share these with you if you can take screenshots of them for the ICC Arbitrators Forum. We also provide for internships at the ICC, both at the headquarters and at our regional offices and branches. So please do keep that in mind if you are interested in continuing to learn about arbitration and at the world's leading arbitral institution. But happy to turn now to some questions from the audience.
Thank you very, very much to Benjamin and Colleen. I think, a lot of information packed in there. I think it's very, very important for everybody to understand how the institution works, because indeed, as we said, the Moot is a wonderful learning and educational journey. And I can fully appreciate having been in that position myself, where you try to understand what the rules mean against this ubiquitous institution. So thank you for bringing some life to that and clarity, more than life. I think you've also taken us through some really wonderful examples of how these rules are actually applied in practice, and I hope that the people who are watching will be benefiting from that, and certainly taking notes on how they can apply that into their current submissions that they're finalizing, and indeed certainly for preparation of the oral arguments. I was wondering, I mean, some of the questions that we've collected as part of the preparations for the presentations is, we of course know that arbitration, each arbitration is unique in a sense. It depends on its own facts, and very, very importantly, as arbitration is a creature of consent, it depends very much on the party autonomy. So, the parties do have a lot of leeway to design the process that they want and make a lot of selections. And as you've already touched on, a lot of the moot teams this year will have encountered this issue of party autonomy versus the application of certain institutional rules, which do give a guidance. Namely, that is under one of the pertinent agreements of this moot problem. The parties have agreed that the tribunal would have jurisdiction to determine consolidation. However, under the ICC rules in particular, that authority on the particular issue lies with the ICC itself. So, I mean, you have taken us through a lot of very valuable considerations. One of the questions that we had is, are there any factors in addition to what is stated in Article 10 that can be considered, or is Article 10 actually considered to be exhaustive?
So I would say that, again, they do depend on the facts of the case. I think that by alluding to other elements that might be relevant, as I was mentioning sort of at the end, I don't think that it's necessarily exhaustive, the things that are provided for in 10C, or pardon me, in Article 10 generally. And also the nature of the proceedings might be different in such a way that those considerations, again, it'll be a question of whether or not they can be cured, or are there such procedural issues. I mentioned compatibility from the arbitration agreements, but there might be compatibility just from the way that the proceedings have been conducted so far. For example, what prior agreements have the parties come to in terms of how they want the tribunal to be constituted, or if they've already decided to deviate from some aspects of the rules. I would say it's not exhaustive. There are certainly other things that we can keep in mind. And we do see that, as you mentioned, it's a question of consent, and that parties can get creative in terms of what they agree prior to even beginning the proceedings. So in arbitration agreements, we do see some particularities in terms of how the parties would like to deviate. We have seen cases where parties have explicitly provided for the tribunal to decide on questions that would otherwise normally be the purview of the court, notably consolidation.
Okay, so do I understand correctly there that, well, I thought initially that this question which we received from one of our students in Kenya, I won't say the team name in case I implicate them or give any hints to the matched memo that they're up against. But do we understand correctly then that Article 10 can actually be amended by agreement of the parties?
I wouldn't say it has been an amendment to Article 10, but I would say whether or not the parties have decided to provide for a derogation of that rule. I think that there are some rules that we're able to allow for parties to agree to. And this is a circumstance that parties may express a desire not to be subject to that part of the rules by agreeing that it will be the tribunal that decides, rather than having Article 10. So in that sense, it is sort of a decision not to have it apply in the same way, in a similar way that parties can agree to opt out of the emergency proceedings. We see that quite frequently. We also can have parties agree to opt in to the expedited procedure provisions, even when they wouldn't necessarily automatically apply. So it's not unheard of for parties to make these sort of agreements. I would say that the rules provide a framework, and there are, again, some that you can't deviate from. For example, we're not going to allow for awards to be issued or notified without scrutiny. But in terms of some of those more procedural questions, we have seen parties able to agree to deviate from those in the agreements themselves.
And I think this also brings in the interplay of the court and tribunals and parties, in that there is, on the overall, a respect for party autonomy. And the court does look into the wording of arbitration clauses and looks to the intention of parties as expressed in the arbitration agreements to see whether parties did want particular issues to be reserved for determination by the court, or for some issues then to go forward to the arbitral tribunal. And obviously the clearest expression of this is in the arbitration agreement. And sometimes parties do come to this agreement later, having been invited to give comments when we write to them. Can you comment on a certain issue? And they come back and say, hey, we've spoken to our counterparts on the other side and we've agreed either one, that we'll consolidate cases, or either we will do something that then makes it unnecessary for the court or the tribunal to make a determination on the issue. And so we see both flexibility, creativity, and ultimately party autonomy come into play in respects like this.
I hope that the Mooties are taking good notes. So certainly there are a lot of, indirect hints there that, certainly can influence, I think, the interpretation that's applied in the arguments put forward. And another question actually from my end is, you, of course, both of you are part of the common law team. So that's your area of focus. But I wonder, might the factors for determination by the ICC or a tribunal be different in matters overseen by the civil law team, or indeed where the applicable law of the arbitration is a civil law jurisdiction?
You mean with respect to the question of consolidation generally, or just how the rules are applied?
I think let's do a two-parter. You've sort of set it up for that. So first with consolidation, and then generally, that would be very interesting to know.
So what I would say is that in terms of our analysis of the rules, we, particularly when we're presenting decisions to the court, we rely on our own court precedent. So we sort of have an internal jurisprudence, if you will, about how decisions should be decided. And I would say that's less dependent on the applicable law. That really is a question of what factors the court takes into consideration based on past decisions and sort of the logic of the rules themselves, to go back to what extent can we deviate from them, or can parties agree to deviate from them. There are some decisions that we will consider the applicable law or the law at the seat when there are mandatory rules that might affect the court's consideration. But this is something that is less of a civil law versus common law breakdown. And I would say it's more a matter of what are the mandatory laws that might be applicable either at a place of enforcement or at the seat of arbitration. Sometimes that will become a factor in terms of deciding on procedural issues.
Very interesting. Thank you. Ben, did you want to add something there? I saw you readying your hand towards your mouse.
I was just thinking about a recent development. Again, we are common law, therefore I say this with great reservation. And I may be corrected by my colleagues in the Paris who sit administering cases at Paris seated, which we don't. But there are examples like challenges to arbitrators, a very jurisdiction-specific issue that has come up in Paris is that you need to ensure that the challenge to an arbitrator has been raised and recorded in the proceedings. Otherwise, then you'll not be able to raise it later before the court if it has not been properly taken note of by the tribunal. Well, do the ICC rules provide for a challenge of arbitrators? Yes. Does it provide for this specificity? No. This is a jurisdiction specific issue. So things like this also show that there is, again, a sensitivity that needs to be given by practitioners in different jurisdictions as to what the mandatory provisions are in the practice or the decisions of the court at the seat. And it also is a bonus. Again, this is me tooting for the court. Having practitioners from all over the world sitting as members of the court who, when an award comes before the court for scrutiny, will flag such an issue to the arbitrators and say there are things that are jurisdiction specific, Mr. President or Mr. Sole or Mrs. Sole Arbitrator, that you should consider when you're looking at the comments, and this will make your award more robust. And I think this is the value add that comes through the scrutiny process.
Thank you. I think that's an excellent point and definitely highlights one of the major benefits of the international arbitration space indeed is having that opportunity to have the diversity just of viewpoints all together in one room, or one Zoom call in the modern era. Well, if Zoom's not your preferred platform, then something else. But indeed, that's very, very illuminating, and I think helpful to know how these processes work behind the scenes, behind what's just reported on in the daily or weekly news on various arbitration cases. And then one final question, which we've received from one of our team members is, well, you've referred, in fact, to how when you're making decisions as the court, as counsel, or giving insight, you refer to internal precedent that guides you in those determinations. But of course, with arbitration specifically, there isn't as strict a notion of precedent being binding as it is in domestic courts, for example. So on that basis, what can you advise the students in terms of finding suitable sources that could guide them, and how to use those sources when putting forward their arguments? And the second part of that question, linked to research and so on, is what sort of databases and I think sources just generally, not other arbitral decisions, can be helpful to the students in ICC cases?
So I would say, first of all, we do collect data, especially we're trying to move towards transparency and having more publishable awards, so that we do avoid the problem of how has the court decided in the past, or how have arbitral tribunals decided when faced with similar circumstances. So we are trying to have a database. Our collaboration with Jus Mundi is also a means of facilitating that, and I would say that's a great resource, because publishable decisions are available on Jus Mundi to be able to see some precedent within arbitral tribunal decisions themselves from awards. In terms of procedural precedent, I believe there are some treatises by practitioners that have discussed ICC case law in particular. We often see them cited when we are getting comments from parties in relation to challenges, for example, or joinder and consolidation. So there are some treatises that are written by well-known practitioners that will sort of look at some of these more discrete procedural issues. And because of their position as researchers in the past, they have been able to get access to some of these decisions and to elaborate on what the patterns are. And so I would encourage students to seek out those resources, looking at, as I mentioned, Jus Mundi, but also then looking out for practitioners' guides to the ICC, and the note as well. The ICC's internal note to parties in arbitral tribunal also tries to shed light on how the rules are actually implemented in the proceedings.
Super. Thank you so much. I hope I didn't put you, well, I didn't mean to put anybody on the spot to name and shame or name drop. So I think that's very, very helpful indeed. And of course, Jus Mundi does provide quite a lot of access to the Mooties, which is a wonderful resource amongst others. But with that, I don't want to keep you very much longer. I know you both are incredibly busy. And I want to close the session with huge, huge thanks to both of you for your time and sharing your expertise and your insights with the group. It's a really, really wonderful occasion, especially since the ICC is involved in the Moot this year. And we are hugely privileged to be sharing the stage with you in this way. And I had mentioned earlier that there's some exciting things coming up, certainly for the whole Moot program. The Vis Moot, as we all know, the pre-moots and practice rounds and all of those things will shortly begin once the pens are down, so to speak, on the respondent's memo in the written phase. And I'm very, very privileged on behalf of Africa in the Moot to also share that the ICC and Africa in the Moot will be partnering towards our East Africa Pre-Moot. So we very, very much look forward to that. For those who have been watching, if you have any interest in being part of the Africa in the Moot movement or finding out more about our East Africa Pre-Moot, please do contact us via LinkedIn, via our website, or you're welcome to contact me personally. And I do encourage you to reach out to those you have seen on the session. Please keep learning. Please, of course, keep your minds open. And we wish you just the very, very best of luck as you complete your Vis Moot process or your legal career. It's not just about the Moot after all. But whatever stage of your career or studies that you're in, we wish you the very, very best, and we hope to see you soon. Thank you so much for your time, and have a good rest of your day, depending which time zone you're in.